Welcome back, students, to the class series of Law and Social Transformation in India. Our next topic is Women and the Law. So let's start. Women are subject to torture. Some of the male-dominated society think that women are inferior to them. But however, as far as law is concerned, women are equal to men because they are human beings and they are part of our life. Almost half of the population around the world, including India, is theirs. Women are the half population, and it is our duty to see that they also live with dignity and protection under the law. So, as I said, women are half of the world's population. Women have right to live in a dignified and secured life. They are strong enough, but they get shattered when their self-esteem is hurt. The dignity of women is much precious than life, and this is a universal phenomenon. Right to life includes the right to human dignity. There are various laws which reinforce safeguards against discrimination and provide for the positive discrimination for women. Crimes against women. Let us see what are the crimes against women. Women have dignity and sexual harassment. All over the world, sexual purity of women is attached to the honor of the family, and therefore, to attack the honor of the family, certain family, the women of that family is actually assaulted. Dignity of women becomes fragile as women have been victims of humiliation, torture, and exploitation. In India, gender-based violence is very common. Perhaps it is deeply rooted in the society. Almost every woman is a victim of violence. Crimes against women includes eavesdropping, molestation, rape, immoral trafficking, sexual harassment at workplace, or domestic abuse. Has put women's right to live with dignity in danger. In Maneka Gandhi versus Union of India, it was ruled that right to live with human dignity is a fundamental right. In Francis Corelli versus Union Territory of Delhi, it was held that right to life means something more than just physical survival, which includes the right to live with human dignity. What amounts to sexual harassment then? Any physical contact in advances, or a demand or request for sexual favors, or sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature amounts to sexual harassment. Laws under which the case can be filed. Section 209 of IPC. Whoever does any obscene act in any public place, or sings, recites, or utters any obscene song, he may be punished with imprisonment of either description for a term which may extend to 3 months, or with fine, or with both. Section 354 IPC. Whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punishable with imprisonment which may extend to 2 years, or with fine. Section 509 of IPC. Whoever intends to insult the modesty of a woman, utters any words, makes any sound or gesture, or exhibits any object shall be punishable with imprisonment for a term which may extend to 1 year, or with fine. Civil suit also can be filed against that particular person. Now, there is a law under the Indecent Representation of Women's Prohibition Act 1987. If an individual harasses another with books, photographs, paintings, films, pamphlets, packages, etc. containing indecent representation of women, they are liable for a minimum sentence of 2 years. Further, Section 7 says, offences by companies. Hold companies responsible for the particular act who exhibits or indecent representation of women. Person guilty of offences under this act shall be punished with minimum sentence of 2 years. Let us come to the Sexual Harassment Act workplace now. Whether in government or private enterprises, inappropriate conduct can be humiliating and may constitute a health and safety problem if it amounts to sexual harassment. It amounts to sexual harassment. It has been laid down by Supreme Court that it is the duty of the employer to see that a work condition has to be created by him in the working place, so that the women should not feel that they have been harassed. These are some of the examples of sexual harassment at workplace. We also have a law now. Earlier in Vishaka's case, the guidelines given by the Supreme Court were treated as a law as long as the law came into existence, and we have now the law coming into existence, that is the Prevention of Sexual Harassment at Workplace Act 2013. What are the steps which has to be taken by the employer? He should notify that at an appropriate place that sexual harassment will not be tolerated. The rules and regulations of the government have to be made known to the employees. As regards private employee, steps should be taken to include aforesaid provisions in the standing orders, as far as the Employment Standing Orders Act 1940 is concerned. Appropriate work conditions have to be made to ensure that the women are safe in that particular employment. Complaints, criminal proceedings, and disciplinary action. An appropriate complaint mechanism has to be created by the employer. Such complaint mechanism should ensure time-bound treatment. The complaint mechanism should be adequate to provide whenever necessary complaints committee. And sometimes the condition is that women should head this particular committee, and not less than half of the members of that committee should be women. And to avoid possible of any undue pressure, they have to see that at least one member from NGO or any other body which has an experience in that particular harassment cases have to be made a member of that particular committee. So in this picture, what you can see is women are working shoulder to shoulder if they are ensured that they are safe in the employment area. Complaints of witnesses should not be victimized or discriminated against while dealing with the complainants. Complaints committee must take an annual report to the government. The head of the organization, upon receipt of the report from the complaint committee, shall, after giving an opportunity of being heard to person complaint against, submit the case with the committee's recommendation to the management. The management of the organization shall confirm it, or without modification the penalty recommended after duly following the prescribed rules. Third-party harassment. So sometimes the ladies may be subject to the harassment from the person who has come into their organization from outside. So, for example, maybe a client. In that case, employer and other persons should see that they help this victim in all possible ways. Other crimes against women recognized by IPC 1860 are Section 312, causing miscarriage. Whoever voluntarily causes a woman with child to miscarry shall be punishable with imprisonment for 3 years or with fine. Section 315, act done with intent to prevent child being born alive, he or cause it to die after the birth, shall be punished for 10 years. Section 372 and 373 penalizes buying and selling of minor girls for prostitution. And Section 361 deals with kidnapping from legal guardian. 366, kidnapping, abduction, or inducing women to compel her to marry. Section 366A deals with procuration of minor girl. 366B, importation of girl from foreign country for the purpose of prostitution, etc. Crimes against women recognized by other laws. Dowry. In 1961, Government of India passed Dowry Prohibition Act, making the dowry demands in wedding arrangements illegal. However, many cases are still being reported. In 1980s, numerous such cases were reported. Now here the condition was dowry prohibition, maintenance of list of presents to the bride and bridegroom rules were framed. Now, in this case, a list has to be made, and then with the names, who has given the gift and what is the value of that gift and to whom it is to be given. But do you think this kind of practice is being carried out? No, such rules are hardly enforced. Now there was one case in 1997 It was reported in 1997 that around 5,000 women die each year because of the dowry deaths, and at least a dozen die in the kitchen fire, thought to be intentional. Now, there was a case in Bulandshahr, where in this case, husband killed his wife after 10 days of marriage, just 10 days of marriage. Female infanticides and sex selection abortion. India has a lower sex ratio, and the chief reason being that many women die before reaching adulthood. Tribal societies in India have a better sex ratio than all other castes, in spite of they are having lower income, they are not literate, but yet they understand the value of the life of a woman. It is therefore suggested by many experts that the low sex ratio in India can be attributed to female infanticide and sex selection abortion. All medical tests that can be used to determine the sex of child have been already banned in India. Abortion permitted on therapeutic grounds. So, some abortions are permitted legally. Okay. Now, there is a law called as Medical Termination of Pregnancy Act 1971, which legalizes abortion. Now, here are the conditions where abortions can be called as legal. The termination of pregnancy is not an offense if there exists of life of a pregnant woman or a risk of grave injury. The termination of pregnancy is not an offense if there exists a substantial risk that the child will be born abnormal. The termination of pregnancy would not be an offense if the pregnancy is caused by rape. Termination of pregnancy is not offense if the couple fail to exercise protection to avoid children being born, extra children being born. Yeah. The Preconception and Prenatal Diagnostic Technique Prohibition of Sex Selection Act 2003. The main object of this an act to provide for the provision of sex selection before or after conception of a regulation of prenatal diagnostic technique for the purpose of detecting genetic abnormalities of metabolic disorder or chromosomal abnormalities. So this is the reason why scanning and sonography is still valid. But even if the doctor comes to know about the sex of the fetus, he is not supposed to reveal that. Okay, he's supposed to only see whether the baby is normal or not. The use of technology of prenatal determination of sex in the context of India is wholly discriminatory to the female sex and has an impact on the status and dignity of women. Large-scale misuse of technologies in future would precipitate a severe imbalance in male and female ratio. So we have to be very, very careful. Now, Honorable Supreme Court amended Section 23. Legislator has increased in Section 23. Legislator has increased the punishment up to 5 years imprisonment and fine up to 1 lakh if there is a sex selection abortion. Human right and unborn child. The basic principle of human right is that all human beings born free and equal in dignity. Human rights are essential to the well-being of every man, woman and child. Right to life, personal liberty and security of women includes her right to terminate pregnancy depending on whether or not the exercise of such right would affect the right of life of an unborn child. The unborn child is a person under Article 21 of the Constitution. Life begins immediately after conceiving, and some believe life begins only after completion of the first trimester. Let us come to the next incident, that is domestic violence. The incidents of domestic violence are higher among the lower socio-economic classes. There are various instances of an inebriated husband beating up the wife often leading to severe injuries. The Protection of Women from Domestic Violence Act 2005 came into force on October 26, 2006. We have another law preventing trafficking in human beings. The Immoral Traffic Prevention Act was passed in 1956. However, many cases of trafficking of young girls and women are being still reported. These women are either forced into prostitution, domestic work, or child labor. Gender injustice and its various forms. Women groups started emerging in India in the early 1990s and at first focus on social reforms. They have also campaigned vigorously and successfully for social and political equality with men. In 1950, women and men over the age of 25 were granted voting rights. Indian patriarchal society not only harbors a culture of violence against women in the form of dowry, domestic violence, and female infanticide, it also manifests in government policies towards women. The unequal representation of Indian women in national political parties is all more disquieting. Despite the deeply ingrained patriarchal attitude prevailing in India, it is one of the few countries even ever to have elected a woman Prime Minister, Indira Gandhi. We still haven't secured 33% reservation for women in Parliament and state assemblies, despite the Women's Reservation Bill being close at hand for so long. The Constitution of India has various provisions to ensure equality of sexes and also to dismantle the prevalent imbalances in gender hierarchy. Article 14 speaks about equality. The Constitution also provides for positive discrimination in certain articles. Article 15.3 permits social provisions for women. Article 16 provides equal opportunity with respect to the public employment. Article 21 guarantees right to life and personal liberty. Article 23 guarantees right against exploitation. It prohibits traffic in human beings. The directive principle of state policy also provided measures for gender equality. Article 39A aims providing the right to adequate means of livelihood for men and women equally. Article 51A E of Constitution provides that it would be duty of every citizen to renounce practices derogatory to the dignity of women. The Indian Constitution calls for 8 years of compulsory education for girls between the age of 6 to 14. However, women still lag far behind men as far as education is concerned. The legal marriage age is 21 for males and 18 for females. A recent law has equaled that particular age. The people of India are guaranteed equal pay for equal work by the Constitution and reinforced by 1975 Equal Remuneration Act. The drawback is that this law does not apply to the agriculture, the area where most women in India are employed. Gender-based pay scale with low wages for female workers are not uncommon. Women are entitled to maternity benefits under the Employee State Insurance Plan, which provides 90-day paid leave. Central government has endorsed the concept of paternity leave for the same duration for men, but this cannot be enforced in the private sector. A woman does not have a right to abortion in India. A Medical Termination of Pregnancy Act 1971 legalizes abortion only in certain cases. There is no provision in the Act which allows abortion on the basis of the will of the woman. The great majority of sexual assault go unreported. Section 397 of Indian Penal Code penalizes offences of rape. The average penalty is 7 years of imprisonment. It is unfortunate to note that marital rape is not yet an offence in India. The only resemblance to marital rape is where the husband has intercourse with his wife without her consent during the separation period. It is punishable with 2 years imprisonment. Initiatives by the judiciary for general justice. Article 51 of the Constitution imposes an obligation on the state to foster respect for international law and treaty. However, the treaty provisions cannot be invoked without the same being incorporated through enabling legislation. The judiciary, through its proactive role, has applied the principles of the treaty in many judgments. So we will see some of the judgments wherein Supreme Court has decided that there should be gender equality and there should not be any kind of discrimination against women. In CB Muthamma versus Union of India, wherein service rules requiring a female employee to obtain permission of the government in writing before her marriage and denying her right to be appointed on the ground that the candidate is a married woman was held to be discriminatory against women. Air India, a famous case, versus Nargis Mirza, the service condition that terminated the services of an air hostess on becoming pregnant was struck down as being discriminatory. In Vasanta versus Union of India, Section 66 of the Factories Act, which prohibit night shift work for women, held to be discriminatory. In Madho Kishwar, Union of India, and C. Masilamani Madliyar and others versus Idol of Swaminath Swami Tirukoil and others, property rights of women were upheld in these cases. in Mrs. Mackinnon and Company Limited, provided for equal wages. Delhi Domestic Working Women's Forum versus Union of India and other cases, provided for compensation in rape cases. Municipal Corporation of Delhi versus female workers, muster roll cases, ensured maternity benefit for contract workers. And in Geeta Hariharan case regarding guardianship rights, interpreted the provisions in favor of women, dealing with the rights of women to be a guardian for a minor child. The Daniel Latis case enabled Muslim women to seek maintenance from divorced husband. Women's Commission. National Commissions. The National Commission for Women was established in the January 1992 under the 1990 National Commission for Women's Act. The National Human Rights Commission was established in 1993 under the Protection of Human Rights Act 1993. The Protection of Human Rights Act 1993 provides for the constitution of National Human Rights Commission and State Human Rights Commission for better protection of human rights and enforcement of the same. The NHRC was set up in 1993. It has empowered to deal with all cases of human rights violation by public servant. Powers of NHRC include inquiry into the violation of human rights, review of constitutional and legislative safeguards for the protection of human rights, to ensure their effective implementation, undertake research in human rights, visiting jails and other places of custodial detention as inspection, reviewing factors including terrorism, recommending remedial measures, encouraging non-government organizations and institutions working for human rights. NHRC has the powers of civil court. So whatever case is filed before National Human Rights Commission will run just like a court case. NHRC has the powers of civil court. Every proceeding before the commission is a judicial proceedings. Empowerment of women. Constitutional and other legal provisions. In ancient India, the women enjoyed equal status with men in all fields of life. Women were educated in Ayurvedic period. Rig Veda verses suggest that the women married at a mature age and were probably free to select their husband. Scriptures such as Rig Veda and Upanishads mention several women sages and seers, notably Gargi and Maitreyi. However, later, approximately 500 BC, the status of women began to decline with the Smritis, especially Manusmriti, and other religious texts curtailing women's freedom and rights. These were some of the examples of ancient women who enjoyed freedom, and after the law came into existence, women's status started becoming a change. Let us come to the incidents where women were treated inferior to men. Are Sati. Sati is an old custom in which the widow was immolated alive on her husband's funeral pyre. Although the act was supposed to be a voluntary on the widow's part, it is believed to have been sometimes forced on her. It was abolished by the British in 1829. There have been around 40 reported cases of sati since independence in 1987. The Roop Kanwar case of Rajasthan led to the Commission of Sati Prevention Act. Facts. Roop Kanwar was a Rajput woman who was immolated at Diurala village of Sikar district in Rajasthan in India. At the time of her death, she was just 18 years old and had been married for 8 months to Mal Singh Shekhawat, who had died a day earlier at the age of 24 and had no children. Child marriage. Earlier child marriages were highly prevalent in India. The young girls would live with their parents till they reached puberty. The child widows were condemned to a life of great agony, shaving heads, living in isolation and shunned by the society. Although child marriage was outlawed in 1860, it is still a common practice in some parts of the rural India. Among Rajputs of Rajasthan, Jauhar was practiced. Jauhar refers to the practice of voluntary immolation of all wives and daughters of defeated warriors in order to avoid capture and consequent molestation by the enemy. You must have seen this particular example in Padmavat film. Next evil of Indian society is Devadasi system. In some part of India, the Devadasi or the temple women were sexually exploited. Devadasi is a religious practice in some parts of southern India in which women are married to a deity or temple. The ritual was well established by the 10th century AD. In the later period, the sexual exploitation of the Devadasis became a norm in some parts of India. Constitutional provisions. of Muslim conquest in the Indian subcontinent brought parda practice in the Indian society. Polygamy was widely practiced, especially among Muslims and Hindu Kshatriya rulers. Many Muslim families, women were secluded to zinan, the part of a house for the seclusion, a sheltered or private place of women. By and large, the women in India face confinement and restrictions. In spite of these conditions, to our amazement, we find many women excelled and found a niche in the fields of politics, literature, education, and religion for themselves. Reformation for liberation of women. During the British Raj, many reformers such as Mahatma Jyotirao Phule, Rajaram Mohan Roy, Ishwar Chandra Vidyasagar, etc. fought for the upliftment of women. Many women reformers such as Pandita Ramabai also helped the cause of women upliftment. In 1917, the first women's delegation met the Secretary of State to demand women's political rights supported by the Indian National Congress. The All India Women's Education Conference was held in Pune in 1927 and in 1929. The Child Marriage Restraint Act was passed stipulating 14 as the minimum age of marriage for a girl. Though Mahatma Gandhi himself married at the age of 13, he later urged people to boycott child marriages and called upon the young men to marry the child widows. We also come across a group of women who had inscribed their names in history. Women played an important role in India's independence struggle. The contribution of great dignitaries like Mahatma Gandhi, Pandit Jawaharlal Nehru, and Dr. Babasaheb Ambedkar cannot be ignored in this case. To make women feel at home in India. Dr. Babasaheb Ambedkar and his movement of women liberation. Upon India's independence on 15th August 1947, the new Congress-led government invited Dr. Babasaheb Ambedkar to serve as a nation's first law minister, which he accepted. On August 29, Ambedkar was appointed chairman of the Constitution Drafting Committee, charged by the Assembly to write free India's Constitution. He is widely regarded as the father of the Indian Constitution for his role. Ambedkar won great praise from his colleagues and contemporary observers for his drafting work. Ambedkar's work would guarantee political, economic, and social freedoms for untouchables and other ethnic, social, and religious communities in India. Ambedkar argued for extensive economic and social rights for women. Constitutional provisions. The Constitution of India guarantees the right to equality and equal protection before the law, right to life, and provides for discrimination in favor of women. Untouchability has been prohibited. Article 17, government recognizes the historical disadvantage and vulnerability of the Dalit women, has adopted several measures to address their concerns, and the same has been highlighted in Article 4 of CEDAW. The government has passed two legislations, namely the Protection of Civil Rights Act, PCRA, and the Prevention of Atrocities Against Scheduled Caste Tribes Act 1989 to enable the Dalits to enjoy human rights on par with other sections of Indian society and empower them in their struggle for their rights. But crimes against Dalits continue to exist. Constitution of India and equal rights and opportunities for both women and men. Article 14 guarantees this. Article 15 also guarantees. Article 53 also guarantees. Article 16 guarantees equality. Article 23 prohibits trafficking in human beings. Article 39A and D enjoins the state to provide equal means of livelihood and equal pay for equal work. Article 42 enjoins upon the state to provisions for securing just and human conditions of work. Article 51A imposes the fundamental duty on every citizen to renounce the practice derogatory to the dignity of women. Article 243D provides not less than 1/3 of the total number of seats to be filled by direct election in every panchayat to be reserved for women. Article 243T clause 3 provides that not less than 1/3 of the total number of seats to be filled by direct election in every municipality shall be reserved for women. Article 243(4) provides a reservation of offices of chairperson in municipalities for SC/ST women in such a manner as the legislature of a state may by law provide. Other legislations, there are several laws enacted by the Parliament of India. Some of them are the Immoral Traffic Prevention Act 1956, Dowry Provision Act 1961, the Indecent Representation of Women Provision Act 1986, the Commission of Sati Prevention Act 1987, the Guardians and Wards Act 1860, Indian Penal Code 1860, the Christian Marriage Act 1872, the Indian Succession Act 1925, the Child Marriage Restraint Act 1929, the Muslim Personal Law Shariat Application Act 1937, the Factories Act 1948, the Minimum Wages Act, the Employees State Insurance Act, the Special Marriage Act, the Hindu Marriage Act, the Hindu Adoption and Maintenance Act, Hindu Minorities and Guardianship Act, Hindu Succession Act, Maternity Benefit Act, Foreign Marriages Act, and so on. The Juvenile Justice Act, Care and Protection of Children Act 2000 provides for protection, treatment, development and rehabilitation of the neglected and delinquent juveniles, including girls. The Information Technology Act 2000 penalizes publication or transmission in electronic form of any pornographic material. The central government has also adopted a code of conduct for internet service providers with the objective of enunciating and maintaining high standard of ethical and professional practices in internet and related services. Panchayat Raj institution, the 73rd and 74th Amendment 1993 to the Indian Constitution have served as a breakthrough towards ensuring equal access and increased participation in the political power structure for women. So we come to the conclusion by saying that the implementation of CEDAW Convention at the domestic or private sphere is still a challenge to be addressed. Government is strengthening the existing legislation and developing institutional machinery. The government has initiated the Sarva Shiksha Abhiyan, a national program for universal primary education. There are several schemes of the government such as Swayam Siddha, the support to training and empowerment program, the Rashtriya Mahila Kosh, the Swarn Jayanti, Gram Swarojgar Yojana, the Sampurna Gramin Rozgar Yojana under the Urban Self-Employment Program, Swarna Jayanti Shahakari Rozgar Yojana. Assistance is provided to the urban poor, especially women living below the urban poverty line, below the poverty line. Whatever is presented to the people through various laws has to be known to them as well. As we know, ignorance of law is not an excuse. Therefore, there is need to go to them and create awareness among the people, especially the women, so that justice will not only be done but seem to be done. Indeed, it is none but the legal fraternity has to shoulder the responsibility. Thank you so much for your patience, and all the best to you, and we'll see you in the next class. Thank you so much.